Good morning. I'm Bill Treanor, Dean of Georgetown Law, and I'd like to thank you so much for joining us for our discussion titled Justice for George Floyd, Understanding and Responding to Minneapolis. This is a very difficult time. The horrific image of police killing George Floyd is seared in our minds and seared in the conscience of our nation. Countless similar horrors have escaped the camera's eye. And now the question becomes, will this increased visibility and undeniability of deep-rooted racism and police brutality lead to the structural change our country has needed for so long? We at Georgetown are a law center and a community dedicated to justice and service. And we now have a very important role to play, which is one of the reasons we're having this discussion. This is the time to channel your energy, your talents, your knowledge, and yes, your anger and anguish and passion for justice into the change you want to ignite. I asked Dean Henning to organize a series of events to help our community understand what happened in Minneapolis, the context around it, and where we go from here. And today, Dean Henning will be joined by other remarkable members of our community, by Paul Butler, by Christy Lopez, by Mary Novak, and by Justin Hansford. However, this conversation will not and cannot end today. And one way we will continue will be through a series of virtual events that will dive deeper into several of the topics that we will be discussing today: police reform, preparing the next generation, and police abolition. I invite all of you to join these events, and I invite you to invite your friends, colleagues, and networks to join as well. The weekly events to follow will be open to the general public as well as our community, and the first is scheduled for Thursday, June 11th. I want to thank you all again for joining, and to so many of you who shared thoughtful questions in advance. And you can also submit questions for our panelists via the Zoom Q&A function at any time during the event. Now, let me introduce Dean Henning. Dean Henning is a true pioneer in the search for racial justice, particularly in the area of juvenile justice. Dean Henning is not only an accomplished scholar in race, adolescence, and policing, she is also the director of our Juvenile Justice Clinic and the founder of the wider juvenile justice initiative she has built around it. Under Dean Henning's leadership, the Juvenile Justice Initiative's work includes conducting racial bias trainings for all parties in the juvenile justice system, a racial justice toolkit created with the National Juvenile Defender Center, and a new Ambassadors for Racial Justice program that she launched for juvenile defenders, also with the National Juvenile Defender Center. Dean Henning is also our Associate Dean for Clinics and Experiential Learning. I am so grateful to her for having put together this extraordinary and important conversation. Dean Henning, I turn it over to you.
Thank you so much, Dean Treanor. Indeed, this is an extraordinarily difficult moment for all of us. We are hurting for George Floyd's family. We are hurting for all of the Black and brown people who look like George Floyd, and we are hurting for our nation. But I, like so many others, refuse to stand by and let George's death be in vain. So I am happy to teach at an institution with the legal knowledge, the resources, and a deep commitment to service and to be of service in this moment. So this program will be educational, it will be empowering, and I am here today with wonderful leaders who have been at the forefront of police reform and who have been thinking deeply about and advocating for radical change in the criminal legal system. So during our time together this morning, we're going to do a lot. We are first going to dive into what happened in Minneapolis. And we're going to talk about the criminal legal implications of the police killing of George Floyd. We will talk about the public's response to this killing. And in particular, why has there been such broad national and international outpouring of emotion at this moment? And we're going to get a little tutorial on protest law. We've received a number of questions from folks asking, what happens if I go to protest? And should I go to protest? We're going to talk about the non-criminal legal remedies beyond the prosecution of these officers. And then we're going to talk about what each of us can be doing individually and as a legal institution. And finally, we will talk more broadly about whether there is a way forward, right? We will think about words like activism and healing and what do they really mean and whether they are really possible in a moment like this. So of course, this is far more than we can possibly cover in the depth at which it should be covered. But as Dean Treanor said, this is just the first of several conversations. We will take an even deeper dive in the weeks to come. As Dean Treanor said, next week, we're going to take a deeper dive into police reform. The week after that, we're going to talk about preparing the next generation for activism and healing. And the week after that, we are going to talk about police abolition. So let's get started and introduce you to our panelists. As Dean Treanor said, I am the director of the Juvenile Justice Clinic and Initiative, and I am a juvenile defense attorney who currently represents clients, children who are arrested here in the District of Columbia. And I am honored to be here with Professor Paul Butler, our own Albert Brick Professor of Law. He is a former prosecutor with the U.S. Attorney's Office and the author of Chokehold and Let's Get Free, Hip Hop Theory of Justice. And I know many of you regularly see him on CNN, MSNBC, and so many other media platforms. I'm so glad you're able to be with us. We also have Professor Justin Hansford, who is the director of the Thurgood Marshall Civil Rights Center at Howard Law School. Justin is also one of our own as a Georgetown Law alum. And he is well known for his work as a leader and an activist who helped empower the Ferguson community during the days after Michael Brown was killed in Missouri. He is a leader in community-based legal advocacy. And then we have Professor Christy Lopez, who is also well known for her extraordinary work in Ferguson, Missouri, leading the investigation of the Ferguson Police Department while she was at the Civil Rights Division of the United States Department of Justice. And she was the primary author of the Ferguson Report. And she's now here. We're so happy to have her here at Georgetown Law, where she teaches courses on criminal justice and police reform and co-leads the innovative policing program. And finally, but certainly not least, we've got Mary Novak, our Associate Director for Nation Formation at Georgetown Law. She's a chaplain, she's an adjunct professor, and she is a former death penalty and activist lawyer, and she is a restorative justice practitioner. So we are so happy to have every one of you here for this conversation. So we're going to jump right in. We have already received more than 100 pre-submitted questions from our audience. And as Dean Treanor said, we will continue to take questions throughout this segment. You can ask questions through the Q&A function. So panelists, people want to hear from you. And so I want to start with Paul to help us set the stage. There is so much history that brought us to this moment, right? This isn't just about Minneapolis, and George Floyd represents so many more people who have died at the hands of the police. But let's do focus for a minute on May 25th, and let's do focus on the killing of George Floyd. And so, Paul, can you help us set the stage, first factually and then legally? You have dissected the evidence that's publicly available. So what did you see And what should we be paying attention to?
We should be paying attention to the facts. On May 25th, someone called the police from a grocery store and said that a man had tried to use a counterfeit bill to buy cigarettes. The police showed up. The store owner explained that the man who had tried to use a counterfeit bill was around the corner in a car. Two officers approached the car. There were three people in the car. Mr. Floyd was sitting in the driver's seat, another passenger in the front seat, third passenger in the back. One officer walks up to the driver's window and talks to Mr. Floyd and immediately takes out his gun and points the gun at Mr. Floyd and orders him and all of the others to get out of the car. They all exit the car. According to the police report, Mr. Floyd initially resisted arrest, meaning he didn't want the handcuffs on him. But once he had the handcuffs on him, according to the police report, he became compliant. The police walked him around the corner from where his car was parked to where their cars were parked in front of the store. Mr. Floyd said that he was claustrophobic and he didn't want to get in the back seat of the car. The officers tried to push him in the car. It was difficult. Mr. Floyd was a very tall man. And so they took him to the other side. And there, the police report uses some interesting language. It says that Mr. Floyd went to the ground face down and still handcuffed. Mr. Floyd went to the ground, still down and handcuffs. So we've all seen the horrific video. He is lying on the ground, face down. His hands are behind his back, handcuffed. The officers then restrained him. Former Officer Clavin put his knee on Mr. Floyd's neck. Two other officers restrained him by the back and by the leg. By this time, a number of passerbys had gathered. They looked at the scene. They tried to help Mr. Floyd, but the officers wouldn't let them. Mr. Floyd said that he couldn't breathe. He said that a couple of times. Mr. Floyd said, "I'm going to die." Mr. Floyd called for his dead mother. The officers restrained him for almost 10 minutes. Officer Clavin had his knee on Mr. Floyd's neck for 8 minutes and 46 seconds. 2 minutes and 53 seconds of this happened after Mr. Floyd was non-responsive. So one of the officers said we should take a pulse. This was about 7 minutes in. When the officer took the pulse, he found none. The officers continued to press down on Mr. Floyd's body for almost another 3 minutes. Mr. Floyd was taken to the hospital and he was pronounced dead. Let's think about the law. First, the arrest of Mr. Floyd. The arrest of Mr. Floyd was for passing counterfeit currency. That's a very difficult crime to prove because you have to know that the bill was counterfeit. You know, our criminal justice system is so biased that when something happens to you as a Black person, you're never quite sure whether it happens to everyone else. But there have been many times when I've been in a store and I paid with cash and the clerk picks up the bill and carefully examines it. And I often wonder, first, what are they looking for? And second, what if it is counterfeit? I didn't know. What would that mean for me? It turns out that those cases are rarely prosecuted because intent has to be proven, and it's difficult to prove intent. So the officer probably did not have probable cause to arrest Mr. Floyd. We don't know why, when he approached the window of Mr. Floyd's vehicle, he took out the gun. I can imagine that Mr. Floyd didn't know that the bill was counterfeit, and he didn't understand why he was being arrested. Under the law, officers do have the power to order the passenger and driver out of the car if they have reasonable suspicion to stop the car. Use of force. In Minneapolis, officers are allowed to use neck restraints if they are necessary in order to force compliance. Police departments have what they call pain compliance techniques, which means that officers are allowed to use force to enforce their lawful orders. In Minneapolis, officers are also allowed to use chokeholds, which is different from a neck restraint. All are very dangerous. A chokehold is especially dangerous because it prevents blood and oxygen from getting to your brain and lungs. So the law in Minneapolis is that the police are only allowed to use chokeholds in a situation in which they would otherwise use deadly force. So in the same context in which an officer could shoot someone, then she's allowed to use a chokehold, otherwise not. But again, neck restraints are permissible under the law. The officers were immediately fired. By immediately, I mean the next day. They were fired in part because of the videos. Numerous passersby took videos. The 4 officers who were involved all had their body cams on. We haven't seen the officer body cam video. We probably will not see that until shortly before or during the trial. We've seen numerous other videos that were collected. 4 days later, former Officer Clavin, who's the officer who had his knee on Mr. Floyd's neck, was charged with 3rd-degree murder and manslaughter in Minnesota. 3rd-degree murder doesn't require intent to kill. What it requires is proof that the officer acted with depraved indifference to human life. 3rd-degree murder is murder. It's not punished as much in Minnesota as 2nd-degree murder and 1st-degree murder. The maximum penalty for 3rd-degree murder is 25 years. Mr. Floyd's family thought that 3rd-degree murder didn't reflect the gravity of the offense. They wanted the officer to be charged with 1st-degree murder, which requires premeditation. The other 3 officers were charged a couple of days ago. They're charged with aiding and abetting the murder of Mr. Floyd. In Minnesota, if you're charged with aiding and abetting, which basically means helping the crime go down, you're subject to as much punishment as for the crime itself. So in this case, the officers are entitled or eligible for as much time as Officer Clavin is eligible for. Also, earlier this week, the charges against former Officer Clavin were upgraded to 2nd-degree murder. The prosecution has an extremely unusual theory for 2nd-degree murder. It's a felony murder theory. So quickly, felony murder, a kind of classic example, is if someone is committing armed robbery, she points a gun at the victim and the victim dies. That's felony murder. In a felony murder case, the government doesn't have to prove intent. It doesn't have to prove intent to kill. It has to prove that one intended to commit another felony and a death resulted. In this case, the government's underlying felony is aggravated assault. So in order to win the case, it would have to prove that former Officer Clavin intended to assault Mr. Floyd, and that Mr. Floyd's death was a result of that assault. The maximum punishment for second-degree murder in Minnesota is 40 years.
Thank you, Paul. It is an excellent tutorial. We have gotten a lot of questions from friends and family about the charges. So this was a really excellent layout. A couple of questions. Can you say more about whether, in your opinion, the charges that we have now are the right charges? And after that, could you also talk to us about the delay? Why was there a delay in the charging of the other three officers? And are they, in your opinion, rightly charged?
Homicide cases against police officers are extremely difficult to win. US cops kill about 1,000 people every year. The vast majority of those killings are ruled justified. The officer used reasonable force under the law. There have been roughly 100 prosecutions of police officers for murder in the last 15 years. About 5 of those 100 prosecutions have resulted in convictions for murder. 5 out of 100. About 25 other cases have resulted in convictions for lesser included offenses, voluntary manslaughter, or negligent homicide. So these cases are very difficult for prosecutors to win. They're difficult because often the other witnesses are police officers. Because of the blue wall of silence, police officers either don't cooperate with the prosecution, or worse, they try to sabotage the prosecution's case. They're also difficult because jurors are very sympathetic frequently to cops. And they think even if the officer made a mistake, she was just trying to do her job. So with that in mind, I think it's very important for prosecutors to bring the case that they think they can win. Prosecutors are the most powerful actor in our criminal legal process. They have more power than the judge to determine the outcome of a case. And a lot of that power lies in their charging decision. They can charge whatever crime satisfies the evidence. There's no rule that they have to go for the crime that results in the toughest sentence. In this case, if we look at the family's desire for Officer Clavin to be charged with first-degree murder, that will require premeditation, evidence that the police planned the killing in advance. Now, it doesn't have to be way in advance, it just has to be a short time. I think that there might be evidence that supports that. I think that would be an extremely difficult case to win. I think intent to kill, a lot of people think that there's evidence of that. Maybe there is. It'd still be very difficult to prove. So again, the interesting thing about this second-degree murder charge is it doesn't require proof of intent to kill. It just requires proof of intent to commit the underlying felony and aggravated assault. Aiding and abetting for the remaining 3 officers seems an appropriate charge. The typical defense to aiding and abetting is what's called mere presence. That is that the person was just at the scene of the crime, but she didn't actually participate in accomplishing it. Now, of the three other officers, two actively restrained Mr. Floyd. One officer kept the crowd away, including a person who said that he was an emergency medical responder and offered to assist Mr. Floyd. That officer might have the least culpability. In the United States, the vast majority of cases that are prosecuted result in plea bargains. There's a Supreme Court case from a couple years ago in which Justice Kennedy says, we don't have a trial system in the United States. We have a plea bargain system. 95% of people who are prosecuted plead guilty. Trials are actually very rare in the United States. People plead guilty because the prosecutor says, if you don't admit you're guilty, I'm going to throw the book at you when I win the case, and I'm going to win the case. Will these officers plead? What we might look for is the officer who, again, might have the least culpability, the officer who didn't actively restrain Mr. Floyd, to make a deal. The deal would be that he would testify against his co-defendants and receive less time. As a defense attorney, it'd be an interesting strategy. Again, statistically, all of these officers will be found not guilty. That's the usual outcome. People say, well, there's video. There are, unfortunately now, several other cases in which there's video, but the officer is still found not guilty. Again, there is you could say a different quality of evidence in this case because there are numerous videos and the videos show the whole encounter, but there's no way of knowing for sure. But again, if I were the prosecutor, I would try to get one or two of the co-defendants to cooperate, to testify against former Officer Clavin. The reason why I think it's important to get a conviction is we all understand the expressive value of the conviction, of labeling, of stigmatizing Officer Clavin as a murderer. The thing to remember is that a not guilty verdict also has an expressive value. A not guilty verdict would say that the atrocity that the whole world has seen is not a crime.
So, Paul, this notion of expressive value is so critically important. So there's one thing to get a conviction or not a conviction on the murder. But I want to ask you one last question because I really do want to open it up to everyone. But what about the duty to intervene? Isn't there some expressive value to saying that the other officers are equally culpable because they didn't stop it? And so can you say a bit about the duty to intervene as a matter of policy in the Minneapolis Police Department and whether there's any hope that we get any mileage from that?
Dean Henning, as you know, I'm a law professor. I teach using the Socratic method. And we're fortunate to have an expert on that duty on our faculty, an expert who actually just wrote a wonderful op-ed in the Washington Post on that subject. So I'm going to call on my buddy, Professor Lopez, to talk about the duty to intervene.
Absolutely.
Okay, so thank you so much, Professor Butler and Dean Henning, and thank you so much for having me here today. I couldn't agree more about the expressive value of intervention and even more so of the failure to intervene. And the law has in fact recognized that officers have a duty to intervene, at least in excessive force cases. And that is really important. I think part of what makes this incident so horrific, and when I'm talking to people when I was watching it, is the same thing that I've seen make similar incidents so horrific in the 25 years I've been doing this work. It's partly the officer who commits the act that makes it so awful. But in some respects, it is a different and an additional harm to see those other officers standing there and doing nothing. Because what that tells communities is that this is not one officer who's out of control or a bad officer. This is the entire police department. This is how they police. They are affirming this. They are condoning this. And communities can actually handle and forgive a department that has one bad officer, right? If they respond to that officer appropriately. But how do you respond to a police department where that's just how they police? There's nowhere to go to protect you from the bad officers if that's the mode of policing. So Minneapolis did have, like many police departments on the books, a requirement that officers intervene. Unfortunately, intervention is harder than any of us would like to admit, and it's hard for police officers as well. It shouldn't be hard. There's no excuse for these officers failing to intervene, but we need to recognize that unless we actually train officers in how to intervene, prepare them for that moment where intervention will be required, and support them when they intervene, then too many officers will not intervene, and more people will die, and more people will be harmed. We can lament the fact that officers need training and that we need to prepare them for that moment. But if we want to actually save lives, we're going to have to go ahead and provide that training and support.
So let's move from there then, from the officer's conduct, and the conduct itself was expressive, and it led to a tremendous outpouring of emotion, of pain, of anger. So let's talk about that. We've set the stage for what happened in Minneapolis with George Floyd and the officers, but let's talk about the protest. And in particular, let me turn to Professor Hansford. The protest started really quickly, right? So by 10:30 a.m. the next morning, the memorials were set up. By 4:30 p.m. that afternoon, the next day, demonstrators had blocked traffic in the area in which George Floyd had been killed. But then shortly after that, we've got headlines talking about people protesting the death of George Floyd across the world: Amsterdam, Tokyo, Paris, New Zealand. So why have the protests been so widespread at this moment? I mean, certainly George Floyd isn't the first person who has been killed, first Black man who's been killed by a police officer. So what is everyone protesting, and why now?
Well, first of all, I just want to say how happy I am to be here to speak to members of the community of my alma mater. And I believe that the widespread interest in George Floyd's killing is part of an accumulation of a tradition of protest, especially since the killing of Trayvon Martin and the killing of Mike Brown. The network of global solidarity that we saw during the protests after Ferguson in 2014 and 2015 has only become strengthened in the intervening 5 years. And so there were allies who were already accustomed to protesting on behalf of the Eric Garner, the Sandra Bland cases. And so there was an infrastructure that is present now that was not present when Mike Brown was killed or when Trayvon Martin was killed. Also, it's impossible to ignore the impact of COVID-19, not only the practical impact of people being out of work, people not having an opportunity to distract their attention from this issue by going out with friends or watching sports, but also the stress of feeling that you are in a state of heightened anxiety because your health is at risk from a pandemic. We know that Black people are over 2 times more likely to die from COVID-19. So you have people facing the stress of that possible attack on their life and their ability to have health and well-being, combined with the intensified attack from racist police violence coming after the video of Ahmaud Arbery, only a couple of weeks beforehand, compounding the stress that was already there. And then, of course, mass unemployment. We think is it somewhere around 25% of Americans are out of work. I think there are new employment numbers that reflect these high unemployment rates. And so the stress of economic precarity, in addition to all of the other factors I mentioned, are setting the scene. But then, of course, I would be remiss if I did not also add the political environment and the rhetoric that came right from the top of our government, which is, as opposed to expressing some type of sympathy or concern, called the protesters thugs and only seemingly sought to make the situation worse. And so if you combine all of those factors, it's obviously the case that people are protesting not only for the George Floyd case in isolation. And there are people there chanting and protesting for a number of outrages, including the political outrages, the health outrages, the economic outrages, and of course the outrage of this ongoing pandemic of police violence.
Absolutely. And Professor Lopez, did you want to add to that? We've talked a lot about the fatigue that the country and the world are facing around police brutality as an impetus for this particular moment.
Yeah, I think there's a couple of things that are important here. One, I remember talking with the students in our practicum this spring when we were talking about the pandemic, and we were talking about different reactions from different communities to stay-at-home orders. And one of the things my colleague and I, Rosa Brooks, Professor Brooks, and I reminded them was that Black men are far more likely to be killed by the police during their lifetime than to be killed by COVID-19. And I think that's an important thing to realize, that we're all living with this fear of an imminent threat that these men have been, especially young Black men, have been living with their entire lives. And I think that that's important to remember now. Almost the flip side of that is that when it began to become clear that COVID-19 was also killing people of color at a different rate, and it became clear that the country was having an entirely different reaction to a threat on our mortality that is less, right? Right now, fewer people have been killed, far fewer people in terms of rate, have been killed in the United States than are killed by police every year, or than your chances of being killed by a police officer if you're Black are. So this difference between our reaction when white lives are threatened versus when Black lives are threatened, I think is very much in people's minds, whether consciously or subconsciously. And the other issue I think that's important is at the very beginning, there was a lot of, and Justin very much, Professor Hansford very much touched on this, there was a lot of the headlines and a lot of the reaction was people are protesting, people in all these different cities across the world and across the country are protesting the death of George Floyd and the killing of George Floyd. And to some extent, that was, of course, true. But to another extent, police officers will also say, we're paying the price for police misconduct that's 1,000 miles away. That's only true to a certain extent. People are very capable of discerning the differences between how they're treated in their own departments and what they see on screens. And a lot of the reaction you see is a reaction to their own experiences in their own communities with police. And I think it's really important to recognize that this isn't just about people reacting to and responding to the killing of George Floyd, although that's obviously an important part. It's a reaction to their own treatment by their own police departments in their own communities. And we have to acknowledge that if we're going to move forward.
So that's a really important point. And it leads me to think about trauma and the trauma that so many folks are experiencing at the hands of the police. And because I represent children in the juvenile legal system, I'm very aware of the traumatic impact of policing on young people. So when I think about this question of why now, I think about all of the Black and brown teenagers who are policed at school, at the park, walking down the street, getting on the bus, sitting on their front porches. And if they don't experience it themselves, they certainly are hearing about it from their friends and family. So it has really been built up over time. And so, Mary, let me bring you into this conversation because you write about trauma. I would love to hear some of your insights about how trauma has likely played into the protests that we're seeing now.
Thank you, Dean Henning, and thanks for this invitation. It is quite simply traumatizing to live as a Black and brown person in the United States. And depending on who that person's ancestors are and if they were slaves, that trauma can be intergenerational. And I am using this word trauma technically here, and we're going to have a session that covers this more fully the week after next. But in short, this trauma eats away at the body, mind, and spirit of the person. And to add to the COVID-19 analysis that Professor Hansford laid out beautifully, there is a trauma lens, right? The COVID-19, the numbers this morning, 110,000 people have died from COVID-19 in the US. And I saw a number that was 3 times the rate for Black folks over white folks dying from COVID. And we don't even have the right numbers because not all counties are collecting race data. And all those layers of trauma are there present. And then the image of Mr. Floyd being killed could only have been devastating. As if we cannot come up with enough ways to kill people of color. Anger, rage, very understandable. And then there are those folks who have opened themselves up to the suffering of their Black and brown community members. And they too were impacted, obviously to a lesser degree. But they have joined, as Professor Hansford has well laid out, because they are angered and enraged as well. Because this is our work together at this time.
So powerful, Mary, and so true. And we will have, like you said, another session on this, and we will elevate this question of trauma and the responses to trauma. We've invited Dr. Hopkins to come week after next to talk with us about that. But I want to sit on this trauma question more, because there is a very complicated question about the videos and the showing the vicarious trauma that comes from watching video after video of Black and brown people being physically abused and murdered right in front of us on national TV. So let's talk about that. A lot of my friends said they will not watch the video. It took me days, to be quite frank with you, to watch the video. I'll be very transparent. I cried when I heard about it before watching the video. So I didn't need to see it to be in pain. But as Professor Lopez always says, we do the work. So we as criminal justice leaders have to watch. But what about everybody else, right? Some people say don't watch Black and brown people being killed by the police, but other people think that it's irresponsible not to watch those videos. And so I'd like to invite all of you into that conversation. Let me start with Mary on that question. What are your thoughts about watching that video?
I'm going to give a standard law professor answer, Dean Henning. It depends. Black folks who live with significant unhealed trauma might not be well served by watching it more than once, if at all, because of the baseline trauma that I have laid out and Professor Hansford has laid out as well. For others, it is more than necessary to watch the video because being uncomfortable is very different than being traumatized. So it's really complicated.
It is, and let's keep that complication going. So, Professor Butler, I mean, definitely want to hear from you. You dissected it, frame by frame. We've heard you talk about it on the news, so I imagine that it had to be painful for you to watch. But so, talk to us. I mean, is there a community responsibility to watch these?
In 2005, an important shift happened that had a major impact on the criminal legal process. In 2005, the majority of Americans had smartphones that record video. And we've seen the result of that. So we can think about two different kinds of groups of people when it comes to the stories and experiences of Black and brown people with the police. We can think about the people who just didn't believe that the police would do stuff like that. And now because of the videos, they know. The other group, though, are people who might have even believed but didn't care or thought that the conduct by the police was justified. But there are a huge number of people of goodwill who now understand. So I think the most important component of analysis of the videos is to do it. If you see the police doing something that you think is wrong, take out your phone. The police are not going to like it. You have a constitutional right, as long as you're not impeding their work, to record what they do. A 17-year-old girl took the video, the 10-minute video of Mr. Floyd's murder. She's a hero. So, watching the video is difficult. I think it's very important to be aware of Mary's comments, that if you're a human being and you watch Killer Mike, the rap artist and activist, calls it murder porn. If you are a human being and you watch this video, it will have an impact on you. It will have a traumatic impact on you. And as Mary said, that trauma might be important for some people. It might be a route to empathy. For those of us who already know, again, we also have to, kind of do some self-care and understand that every time we watch that video, as a person of color, we're diminished.
So let's sit there for a second and talk about, you referred to the 17-year-old girl who took that video as a hero, and I absolutely agree with that. And it's hard to stop and watch. It's hard to stop and intervene in the moment when you're there because it's so painful, right? But there are also, we've gotten a number of questions from people who are afraid to be out in the streets and to stop, afraid of what the police might do if they pick up their cell phone and they start recording. We've heard stories about it. So I want to turn to Professor Hansford, who is, a community activist and has been really at the forefront of talking about protest law. And so I'd love to hear from you. Professor Butler's already said there's a First Amendment right, to be there, to pull out your phone. Can you say a bit about, first, what are the risks that people face when they stop and they engage in those ways? And then how does the law protect them?
Sure. Well, I actually wanted to put a link in the chat for people who want more information on something called Cop Watch, which Professor Butler mentioned. There is a right to observe police in almost every jurisdiction, to observe police activity in public. And the fear that people have of even stopping to observe is one that also demonstrates how this idea of police as public servants has really been replaced by this idea of police as potential sources of violence towards people, even if they're not breaking the law, but simply seeking to do regular human things like try to protect people they see in danger. But when it comes to the First Amendment and the right to protest, there is also the question of whether or not people are going to be able to have their rights recognized, regardless of the fact as to whether there is some sort of property damage taking place at the protests, in the context of possible imposition of curfews. How are our First Amendment rights being limited by the imposition of curfews on protesters? And finally, the question of liability and criminal prosecution. We know that since the protests in Ferguson, in over 120 different cities, there has been a proliferation of ordinances and also state statutes designed to do everything from allow there to be felony rioting charges brought against people simply for refusing to agree to dispersal orders, the idea that there would be a limitation on liability for people harmed if they were blocking the street, harmed by police. We also know that there was a case that's now in the Supreme Court involving the activist DeRay McKesson, in which a police officer was hit by a rock. DeRay McKesson had been proven not to be the one who threw the rock, but he had encouraged people to go to the protest. He did not incite that violence. He did not encourage that violence, but he was still found liable in the district court. And the district court did not agree, but the Fifth Circuit overturned the district court and found that liability could be pursued under a negligence claim. And we're now appealing that to the Supreme Court through our Thurgood Marshall Civil Rights Center, hoping to overturn that dangerous precedent. So there has been a number of attacks on the First Amendment right to exercise our ability to engage in what I believe is political speech, this protest speech. And it's important for us to fight those battles in the courts, fight those battles in the legislatures, but also go out and assert our rights on the streets as well, to make sure that those rights are vindicated.
So let me say two things. First, Professor Hansford, you referenced a link to Cop Watch, just so that everyone who's watching knows you do not have access to the chat. However, we are working on developing a website where we can link all of the resources that you're going to hear about both today, this morning, as well as in the subsequent panel. So there'll be a one go-to place for those. But Cop Watch is a great resource, and you can Google that in the meantime. We are also still taking live questions. And one of the questions we received right on this point is, what if the police prevent you from physically recording or prevent you from recording by like physically taking your phone from you? So I want to turn to Professor Lopez. I know you have dealt with these issues when you were at the Department of Justice. Is that correct?
When I was at DOJ, it was a very different DOJ. And one of the things that we did was when cell phone use was becoming more frequent, as Professor Butler talked about, and police didn't, well, there were a lot of different responses from police officers to being filmed, as there still are. And a very frequent response was to take the phone, destroy the phone, erase the photos on the phone, arrest the person, which raised both First and potentially Fourth Amendment issues if you're arrested. And what we were seeing is that some courts were likely to dismiss charges against you, but would still not grant you a would fine for you in your affirmative Fourth Amendment claim. And they especially were not very convinced by people's First Amendment claims. So we as the government weighed in on the side of the plaintiffs in those cases, arguing on behalf of the First Amendment and the Fourth Amendment in cases brought by private plaintiffs. There has been a sea change in the law, and there is now more respect for people's right to record, and you are more likely to prevail for exercising those First Amendment rights and less likely to have your Fourth Amendment rights violated with impunity. That said, it does absolutely still happen, especially for people like DeRay McKesson and others, and when you're in places like the Fifth Circuit, but really anywhere. The government will use this to try to make an example of you, and it's really a problem that we need to keep working on. And I think that comes from, especially now, that really has to come from state and local communities to press their jurisdictions to protect residents' right to record.
So before we move off this, I want to ask one last question on this issue of protest, and I'm going to ask Professor Butler if you could just say a word to us about government intervention, much broader intervention in protesting, and in particular the use of the military to clear the way for political leaders to speak. What are your thoughts?
So that's an issue right now in the District of Columbia. The President of the United States is the Commander-in-Chief of the National Guard of the District of Columbia. Traditionally, though, the mayor of the city has had the same authority as the governor of a state to call out the National Guard. That changed this week when President Trump invoked his own power to call out the National Guard. In addition to the Metropolitan Police Department and task force of other National Guards and local police. So they were all in Lafayette Park for the police violence that went down there on Monday. The District of Columbia's position is that the president does not have the authority to invoke the military power that he has to patrol the streets of the District of Columbia. One of the concerns is that other federal police departments have been deputized to patrol DC streets now, including correctional officers from the Federal Bureau of Prisons. So these folks have no training about how to do civilian law enforcement, but that's exactly what they're doing now. There are many reports of protesters in DC being arrested by officers who did not have badges or uniforms. There are people who are being arrested now who don't know who they were arrested by. The District of Columbia has a long experience with protesting and policing. As a result of that, there's actually good law. The question is, will that law be enforced? So for example, the law in the District of Columbia is that when a police officer is making an arrest of a protester, she must wear a badge. Her identity must be known. That law is not being respected in the district right now.
I'm so glad that these conversations are happening about how to protect our right to protest. So there's so much more we could talk about on the protest side, but let's go back and talk some more about the officers. And we've gotten so many questions about that. And as we began to shift the remainder of our conversation into what can we do from here, let's talk about police reform. So Professor Butler talked to us about the criminal legal implications, but I want to turn back to Professor Lopez to talk about whether or not there are other legal remedies against the officers, both in their individual capacity and then against the department as a whole.
Yeah, I think that's a really important question because remember, criminal penalties are backwards looking, but if you really want to focus on, and they may have a role in prevention as well, but there are many other remedies that are much more focused on preventing these sorts of incidents, and that's obviously important. And as you, unfortunately, the law has made it increasingly difficult to prevail against the police in pretty much every potential legal avenue. One avenue against the individual officers would be a civil suit. You can sue either the individual officers or you can sue the police department civilly. The suit against the individual officers, there have been a couple of dynamics that make those difficult. One of the ones that's very much in the public eye right now is the issue of qualified immunity. We can go into that, maybe we'll go into that more in the next panel, but suffice it to say that in 1871, as part of one of the Reconstruction statutes, the Congress, as part of the Civil Rights Act, gave people the right to sue government officials for violating their constitutional rights. And ever since then, the Supreme Court, through a completely judicially created immunity called qualified immunity, has been narrowing that ability to the point where at this point you have to have a case in that same circuit that is exactly on point. So for example, and remember, this is just, you have to pass this threshold, as I tell my students, to even be able to have the conversation. You don't win if you can meet this threshold, you just get to make your case in court. And we're preventing people from even having that conversation by saying that the officer is protected by qualified immunity. And so, for example, there are a few cases before the Supreme Court right now where they're considering this. In one case, an officer was chasing someone through a backyard, goes into a backyard, yells to get down. A 10-year-old boy goes to the ground. There's a non-threatening family dog there. The officer shoots the dog, and the boy is struck in the back of the knee. He lives, thank God, but he is seriously injured. The lower court there said that the officer was entitled to qualified immunity because it wouldn't be, there's nothing exactly on point. Similar case where there was a man who was attacked by a dog while he was where he was completely passive by a police dog. And the court said, well, there was a case where we found liability where the man was.
Yeah. So Christy, you're Professor, you're cutting out a little bit. So Professor, you're cutting out a little bit. So I'm going to ask.
There's a unpacking. Not convinced that changing quality will be the solution. Will be actually should be another problem of this.
So we've muted Professor Lopez, and both Professor Hansford and Professor Butler, if you want to jump in there and talk about she was closing the loop on qualified immunity and why that makes it so incredibly difficult to sue officers in their individual capacity. And I also wanted to hear a bit about the opportunities to sue the police department as a whole in response to George Floyd's killing.
Sure. I can speak briefly about qualified immunity, and I know Professor Butler is an expert as well. But one interesting fact about this is there's a scholar named Joanna Schwartz who has done research on this issue, and she has found that in over 99.5% of cases where police were found to be liable for violating a citizen's civil rights, over the course of their policing, those police officers did not pay damages out of their own pocket. Those damages are indemnified and paid by the cities. And so when you combine the fact that it's so difficult for us to have successful criminal prosecutions of police, with prosecutors being very hesitant to bring any charges at all against those police they work so closely with, and this almost full indemnification coming when it comes to the civil aspect of the law, it is really true that the police may feel like they literally have a license to kill with no real accountability coming from either the civil or the criminal side of the equation. And so the push to eliminate qualified immunity would be a step in the right direction on that point. We've seen interest both from the Cato Institute, libertarian organization, and of course from more progressive advocates. So there is a possibility that this could be the beginning of some sort of legal intervention. Problem, of course, is that many police officers may be judgment proof themselves when it comes to their own financial ability to pay damages. So those problems have not been solved. You know, people have thought about maybe creating a separate fund for police brutality victims that could address some of these issues. But there are many proposals on the table on that question of qualified immunity.
I understand the urge to hold officers liable, either criminally or civilly. Check this out. Black people are 20% of residents of Minneapolis. 60% of the people who are killed by police are African American. Bringing a criminal prosecution or a civil suit against an individual officer isn't going to impact that. That's a structural problem. And now there's a civil rights investigation of the Minneapolis Police Department by the Minnesota Civil Rights Board. Professor Lopez, when she worked at the Department of Justice, did pattern and practice investigations of police departments all over the country. That's a much more effective route to systemic change.
So fortunately, Professor Lopez is back, and this is a perfect time to transition to you to talk, right, about, as Professor Butler said, the pattern and practice work, but also you are really truly a leader in policing reform more generally. And I would love to hear from you about what you think is the path forward, short of those legal remedies, to reforming police today. You're on mute, Professor Lopez.
Thanks so much. I apologize for that. Thanks so much. I appreciate that the point that police reform is obviously much more than these pattern or practice lawsuits, even when you're talking about systemic reform. And we should note that private plaintiffs can bring pattern or practice suits, as can the government. There's some additional hurdles that private plaintiffs face, which we should think about removing. But I have always said, and certainly my work has taught me, that consent decrees and those pattern and practice investigations are not going to fix policing. We need to do much more. The entire criminal justice system reflects and reinforces problematic policing. And really, in many respects, we need to keep in mind that policing and many of its problems are a reflection of our 400 years of really problematic history, to put it mildly, of oppressing people on the basis of the color of their skin and where they're from. So that's not going to go away. And we need to be working on that in all of our institutions, policing included. But one thing I want to focus on or just remind us of, and again, we'll probably get into this more in the panel on police reform, is the importance of action and the effectiveness of action at the state and local level, both in your police departments and in your prosecutors' offices. But remember, it is the states that decide what the crimes will be. And so they really set the parameters for what policing will be. They are the ones who decide what the penalties for violations will be. They can set things like use of force standards. There are 18,000 police departments in this country. And so it's very important to look at the 50 peace officer standards and trainings groups in every state. They set the training, they decide how an officer gets certified and decertified. And we can really look to them to require them to require particular training of officers and to decertify officers when they behave inappropriately.
So we'll have a full panel discussion on police reform, and I very much look forward to that. And we will also have a panel discussion on police abolition. And people are asking the question: so what does it really mean that we will have no police in the United States? So, Professor Hansford, do you want to say just a sentence about police abolition, and then we'll leave it for the later panel discussion?
Sure. Police abolition is not a overnight proposal. Many people, I believe, hear that phrase abolition, and it's almost like a boogeyman, and they think that people are asking for all the police to go home today. The idea behind most police abolition proposals, and again, I'm sure we'll get into more depth in future discussions, is to systematically replace functions that currently are fulfilled by police with other more appropriate services. If somebody is having a mental health issue, as opposed to calling a police officer who might use deadly force, call somebody who is trained to deal with mental health issues. Take police out of the public schools. So there are many different efforts that, again, we can provide more information about the proposals for police abolition. One of the most important things to think about when you think about that discussion is the invest, divest framework argued for by the Movement for Black Lives. I think the city of Los Angeles has provided a model over the course of the last 2 days. They took $150 million from the police budget and invested that in Black communities, which is something which is the best model of abolition. We live in a country where we don't have enough ventilators for people in hospitals because we can't afford it. We don't have enough books in the schools, but the police have money for tanks and tear gas and all these other things. And so the divestment from policing and the investment in other social services in our society that's an abolitionist project. So it's not necessarily a complete vacation or for all police. You know, it's a situation where there is a progressive step towards a more just vision of how we create public safety in our society.
So we look forward to hearing more from you about that, and Professor Lopez about that in our subsequent workshops. So let's use our last 15 minutes together to talk about what the main question everybody has written in about is: what can I do? What can we do, both as faculty, staff, students, activists, folks who are watching us in the larger community? And so I want to start with you, Professor Hansford, and then I'm going to come back to Mary Novak because I want to hear what's going on at Georgetown. But Professor Hansford, if you got the question, what can I do? What would you say? And I want you to answer that question for lawyers and non-lawyers.
Sure. So I have been using this chat option and sending links. The first thing I sent, I wanted to provide some context. I think that link I sent did work, Chris, from what I understand.
Yeah, Professor Hansford, though, the problem is only the panelists can see the chat.
Okay.
So the audience, we've got about 600 to 800 people on there. They can't.
They're saying they can't see it, but I'm going to put this out here so people just.
They can see it. I've gotten a new message. We've been corrected. You can see it. Thank you.
To provide context, I sent out a link for something called the Bail Funds, which is a fund which allows people to contribute to bail funds for protesters around the country. I stress this as a first option because in this time of COVID, people cannot social distance when they are in jail for protesting. And my biggest fear in this entire context is mass arrests where people are forced to be in cells, 10, 15, 20 people at a time, and a person in that cell having COVID and spreading it to the protesters who are trying to do the right thing. So please, if you are able to contribute to that, whether you're a lawyer or not. Another option is serving as a legal observer. The National Lawyers Guild has a legal observers program, which allows legal workers and non-legal workers who are trained for it can also participate as well. But this allows you to go into work closely with other legal observers and ensuring that people are having their rights recognized by the police, observing the police in their interactions with the protesters, making sure that people know that they have rights, and even your presence as a legal observer with it, they give you a neon green hat to put on, and you stand there, and even your presence can give confidence to the protesters to know that somebody's there looking out for them. And it may also dissuade police officers from taking the most aggressive approach in terms of their tactics. And so for those who can go out and legal observe, I encourage you to do that. For those who cannot go out and legal observe, I encourage you to contribute to something like a bail fund. There are other efforts happening in terms of the legal community to file lawsuits to try to get the curfew lifted. Our Civil Rights Center filed a lawsuit to do so. There are other groups that, including the ACLU and other groups, the Lawyers Committee for Civil Rights has filed a lawsuit. So feel free to contribute to those organizations as well, that those public interest legal organizations that are working to try to fight these battles in the court. I can drop a link to ours right here, and feel free to contribute if you have an opportunity. But these are all different options for ways that you can contribute, whether or not you can take your body to the protest, or whether or not for health reasons or for other reasons you'd rather do something from home. Please find a way to support this cause for justice if you have the inclination to do so.
Thank you, Professor Novak. Let me turn to you. Thank you, Professor Hansford. Let me turn to you, Mary Novak. Can you say a bit more about what students, staff, faculty might do within our community and beyond?
I will, except I'm going to ask Professor Hansford one last question. Do you have to be a lawyer to do legal observation?
No, you do not have to be a lawyer.
Awesome. That's really important for our folks to know. So this is also going to be picked up in another panel later on, but in short, we all have to be doing our work interiorly and exteriorly because this is long haul work. Ongoing healing from trauma of these days is really important, coming together in community to make meaning together. This is the kind of space we create at Georgetown Law School with the Black Law Student Association, Sankofa retreats. I also know that they've gathered this week, as well as many other Georgetown University Law Center student groups, as well as our interfaith chaplaincies. Expanding your mental models to understand just how enshrined and systematic racism is in the United States and how white supremacy operates. This includes white folks getting really uncomfortable all the time and staying there, viscerally uncomfortable. We've got to do the root cause work, naming our country's original sin of slavery as the taproot with its tendrils in our criminal legal system, of course, and tapping into the work of the narrative changing that has been done by such heroes as Brian Stevenson through the work of EJI's Peace and Justice Memorial. If you haven't seen Just Mercy, you have no excuse now. It's free online. So do that work right now because this continues to be long haul work.
You're absolutely right about the depth. It's not just the action items that we do. I want us to do everything that Professor Hansford said, but then also the deep work that Mary talked about, that internal work, and looking ourselves in the eye as a community. And let me ask you about this notion of activism and healing. We've had a number of conversations about that. Folks cringe when we use the word healing, when we talk about racism in America and policing in America. So I would love to hear from Professor Lopez say about that. Can we have healing without activism, and how do the two go hand in hand?
So I feel humbled to even be talking about this, but I will just say that in my view, I think the challenge, and I feel almost like I should be saying this, but I think we can learn a lot from James Baldwin and the way the Ta-Nehisi Coates repeated this in their conversations about the need to be able to find a peace and not let racism pull you, sort of destroy you from inside, while at the same time not letting that make you complacent and being able to continue to fight for things. And that, I think, is the challenge that all of us have, but I think Black people and other people of color, it is a different thing, obviously, and I can't really speak to it. It's not my place to speak to that more than that. But I will say that there's something that I think about, and I think we should all be thinking about that every day. And just shifting gears just slightly, to be allies in that, I think the thing that many of us can do who do not face this direct risk, white people essentially, we should be listening, we should be learning. And that doesn't mean peppering all of your African-American friends with a bunch of questions, which there may be time and place for that, but read and learn. And most importantly, in my view, commit right now to the things they're going to do once the news cycle has shifted to bring this home, because that has always been the problem in this space, is we have an intermittent commitment to this, and this is a problem that is much too big and much too entrenched to be able to be one if we fight it only once a year, once every 2 or 3 years. We have to commit to fixing this until it's done.
And I'm going to call on Professor Butler to say a word about, can we get to healing? Some people have said to me, we're all too angry to talk about healing yet, but can we get there, and how?
When we think about what we ask the criminal legal process to do, which is to identify the people who are the most dangerous or the most immoral, and then to adjudicate them, and then to punish them. But we know that there's no way that we can do that in the United States that's not all about race and class. And so we have to think about transformation. We didn't talk about reforming slavery. We talked about abolishing it. We didn't talk about reforming the old Jim Crow. We talked about abolishing it. And so I don't think we can exclusively focus on reforming the new Jim Crow. I think we have to think about transforming it and what it would mean to have a response when people are in danger that doesn't only involve calling people with badges and guns and the power to arrest. On the way to that, reform is important. Reform means that even if transformation doesn't happen, that the police beat up fewer people, that the police kill fewer people, that the police don't arrest Black and brown people in situations in which they wouldn't arrest white people. I think we all kind of feel uncomfortable talking about transformation and healing, other than our wonderful Mary Novick, because the rest of us as lawyers, we feel like maybe that's not our bailiwick. Maybe we haven't been trained in that. Lawyers are really good at reform, and that's something that we can work on in terms of law and policy. It's something that I'm so proud that our students right now are really involved in. And so that's what gives me encouragement. That's what kind of keeps me going.
Excellent. Thank you so much. Professor Butler, you have really teed up our series beautifully for the next 3 weeks. I hope that all of you who are listening have found a piece that you want to do, something active that you can hold on to, that you want to do both internally and as an action item. I hope that you have been intrigued by what you've heard so that you will continue to join us for the next 3 weeks. Next week, Professor Lopez is going to lead us in a deeper dive on reforming the police. That will be next Thursday, June 11th at 2 p.m. And I actually apologize. Professor Rosa Brooks is going to moderate that panel, and Professor Lopez will join her. We will also hear from police leaders at that panel who are committed to reform and who are engaging us. A number of us are working with the Innovations in Policing program, and you will hear from one of the officers who is working closely with us, partnering with us on innovations in policing. The next panel will be the following week, Thursday, June 18 at 11 a.m. And that's preparing the next generation. That's this conversation about activism and healing, understanding that healing doesn't come without structural reform, but that we've got a generation of young people. We're all working with our students. We have children of our own. We have teenagers who come to us and they ask us what to do and how to move forward. So we're going to talk about that. We're going to have Professor Anthony Cook, Dr. Justin Hopkins, Professor Amy Ullman, and we're going to have Judith Brown Dianis from the Advancement Project to come and talk about working with young people. So we're really excited about that panel. And then finally, we're going to circle back to this discussion about police abolition and what does it mean. And that panel will be on Wednesday, June 24th. And that's when Professor Lopez will come back and moderate. And you will hear from alums. Our wonderful Janae Stasier will come back. Professor Allegra McLeod, Professor Justin Hansford will come back. And I think we have one additional panelist. Professor Lopez, you can let me know who that is. Linda, you're muted. That's okay. So we'll come back. But just we look forward to seeing you all. Thank you so much. This is a difficult moment, but again, I am very happy to be a part of this community where we can be of service. Thank you, and we'll see you next week.